Good morning, everyone. Thank you for attending this preliminary hearing for the Scottish COVID-19 inquiry. Before we start, I want to apologise for the late change to the mode of delivery of this hearing, and thank you for joining online. A recording of this hearing will be saved and made available on our YouTube channel. There are several reasons why I decided to hold a preliminary hearing today. First, I would like to give co-participants an update on the inquiry's work, including our plans for hearings in 2026. Second, I think it is important that, as Chair, I set out the parameters of this inquiry's work. I want to be clear, well ahead of publishing our final report, on the approach that I am taking to the scope of the terms of reference set out by the Scottish Ministers. Finally, I want to explain to co-participants and their legal representatives some procedural decisions I have taken which will apply to the next two stages of the inquiry's hearings, namely implementation and decision-making. Today, there will be no statements from Council to the inquiry. Instead, I will set out my position on the matters I have just listed, and then I will answer any questions directly related to those matters. Immediately following my remarks, we will have an adjournment of 40 minutes to allow legal representatives to consider what, if any, questions they wish to put to me. If a legal representative does wish to ask a question, these should be emailed to the co-participant mailbox within 20 minutes from the time of adjournment. I and my team will then consider the questions before recommencing the hearing. I will read the questions and my responses out. If any question cannot be answered today, a response will be issued to all co-participants via the co-participant mailbox by close of business on Friday, 13th March. Turning to the first issue, I would like to give an update on the inquiry's work and plans for the future. The inquiry started its public hearings by listening to the oral evidence of the impacts of the pandemic on the Scottish public. This included listening to the families of the bereaved, those separated from relatives in care homes, those who lost out on education, whose business or places of worship were affected, or people impacted by delays to the justice system. The evidence covered during those hearings was both wide-ranging and sometimes deeply personal and distressing. I am very grateful to all those who participated. We completed these hearings in June 2025. In September 2025, the inquiry took evidence for a second time from Dr. Ashley Croft for the purposes of having him answer questions put forward on behalf of the co-participants. That was followed immediately by 2 weeks of roundtable evidence sessions with expert witnesses which examined the use of lockdown and other non-pharmaceutical measures. Experts from a wide range of disciplines discussed what actions could be taken by governments to deal with a public health emergency and the factors that need to be weighed when making such decisions. Later this year, between 5th and 23rd October, the inquiry will hold its next set of oral hearings to hear evidence from some organisations that were responsible for implementing the decisions made by the Scottish Government in response to the pandemic. The inquiry will hold its last set of hearings by hearing the oral evidence of decision makers during the pandemic. This will include Scottish ministers who were responsible for strategic decision-making during the pandemic. It is likely that we will also hear from senior advisors to the Scottish ministers during those hearings. I indicated in June 2025, at the end of the impact hearings, that the inquiry would start and conclude its remaining hearings in 2026. I regret to advise that that will not be possible. I will provide an update on the decision-making hearings at the conclusion of the hearings in October of this year. The inquiry has taken the approach of hearing first from those most affected by the pandemic, in order that their evidence could be used to help inform our investigations. Then it will turn to the organisations which were responsible for implementing the decisions of the Scottish Government before turning to the decision makers themselves. The evidence ingathered is being used to guide our investigations of the decisions made and the process leading to those decisions. Structuring our investigations in this way means that the inquiry can ensure that it has at its full disposal all available evidence before hearing from the senior government officials and elected ministers who were responsible for taking the decisions on how best to respond to the pandemic. I would like to turn now to other inquiry activity for 2026. This year, in addition to hearings on implementation, the inquiry will publish a series of narrative records which summarise the evidence we heard about the impact of the pandemic. There will be 5 separate narrative records, broadly mirroring the structure of our impact hearings. These narratives will cover evidence gathered by the inquiry on the impacts on health and social care, education and certification, business and welfare, justice, worship, and equalities and human rights. We will publish later this month the narrative record relating to health and social care, which will summarise all the oral evidence heard during the 16 weeks of public hearing on that subject. We will also publish statements taken from witnesses who were not called to an oral hearing. This will be followed in the coming months by records covering the other subjects I have mentioned. Those narrative records, in addition to the evidence led in oral hearings, include other evidence gathered by the inquiry but not led in a hearing. I would like to stress that these narratives are simply thematic summaries of evidence. They will not include determinations of fact or recommendations. However, these records represent an important part of the inquiry's evidence-gathering process, and I hope will demonstrate to core participants and to the wider public my commitment to openness and transparency. They will provide a permanent record of the experiences of the people of Scotland during the pandemic in a relatively concise format. Publishing the narrative records at this time will also enable the inquiry to focus on determinations of fact and lessons learned for the final report. Therefore, in my final report, I intend to avoid repeating the information that we will already have published through these records. Instead, where appropriate and necessary, reference will be made to the relevant portions of the narrative records for context. The inquiry will share draft versions of each narrative record with core participants who had leave to appear in the relevant impact hearings ahead of publication. Those core participants have and will be asked to provide any comments they may have on the narrative records before publication. We have already done so for health and social care. Excuse me one moment. Thank you. Turning now to Let's Be Heard. In 2026, the inquiry will also publish 4 volumes from Let's Be Heard, the inquiry's listening and public participation project. The Scottish COVID-19 inquiry is one of the largest public inquiries ever undertaken in Scotland, given that the pandemic affected the lives of everyone living in the country. It is not possible to take statements or hear oral evidence from every individual who may want to contribute to this inquiry. The primary purpose of Let's Be Heard, therefore, was to create a mechanism by which all members of the public in Scotland could contribute to this inquiry by sharing their own experiences of the pandemic. The Let's Be Heard team gathered experiences from over 12,500 individuals, including children and young people. Through a programme of focused engagement, The team ensured they spoke to groups of people in Scotland who are often underrepresented and harder to reach, providing an important source of data. This is one aspect of how we are taking a human rights-based approach to our work. The Let's Be Heard team is presently busy analysing all that data, and we intend to publish the results of their work in the second half of 2026. Now I would like to turn to my second set of remarks concerning the inquiry's scope and terms of reference. The terms of reference for this inquiry were set by Scottish ministers in consultation with the Scottish public in September 2021. Excuse me again. There are 12 terms of reference and a series of reporting requirements for me to adhere to as chair. These are set out on our website. As inquiry chair, I cannot explore matters that do not fit with the inquiry's terms of reference, nor can I explore matters which sit outside the inquiry's official timeline of January 2020 to December 2022. From time to time, the inquiry receives representation from individuals and co-participants to explore some issues that are outside the scope of the terms of reference, either in terms of subject matter or the date of the events. I cannot do that. Like all inquiry chairs, I must adhere both to the terms of reference and the legislation under which the inquiry was established. In this case, that is the Inquiries Act of 2005. The terms of reference are extremely broad and cover several sectors of society. In order to fully inform the questions that will be put to the decision makers, the inquiry has heard from a wide range of individuals and organisations regarding the impacts they experienced. Some of that information was very specific regarding their experiences or those of their loved ones who died during the pandemic. I must stress, however, that the inquiry is required by the terms of reference to investigate and report on the strategic response to the COVID-19 pandemic in Scotland. This means considering and learning lessons from the strategic decisions that were made or not made. It includes looking at who made the decision, whether that was the right person or body, the information that was available and relied on when making decisions, the process of obtaining that information relied on, cooperation between departments, governments and the third sector, the quality and clarity of the decisions made, and whether decisions were revisited at appropriate intervals to reflect the changing events or feedback on their impacts. I will not make findings in connection with individual deaths, nor the actions of individual doctors, clinicians, carers, or care home providers. Rather, I will look at the strategic decision-making that occurred and the extent to which that resulted in the types of outcomes that the inquiry has been told about by the witnesses. I have seen occasionally reported in the media that some people impacted by the response to the pandemic want to see individuals held accountable, sentenced, or even imprisoned. I do want to manage expectations and would ask that the legal representatives of co-participants help to do the same with their clients. I am not empowered to make civil or criminal findings against anyone. I will make findings of fact that may include criticism of decisions or actions of individuals. The purpose of this inquiry, however, is not to sanction, but rather to establish the facts of the strategic response to the pandemic, to learn lessons from those facts, to make recommendations, and to report all these things to the Scottish ministers. When doing so, I will consider the impacts of the strategic elements of the handling of the pandemic on the exercise of convention rights as defined by the Human Rights Act of 1998. I will also, as I deem necessary and appropriate, consider any disparities in the strategic elements of handling of the pandemic, including unequal impacts on people. Again, this will not deal with the specific circumstances of any individual, but rather on the impacts of people or groups or sectors of society. I think it is also important to make clear that the inquiry will not be in a position to follow up on every impact that evidence was given about. There are a couple of reasons for that. Firstly, the scope of the terms of reference are such that they must be interpreted to ensure that the inquiry carries out a meaningful investigation within a reasonable time frame and with due regard to avoiding unnecessary expense to the public purse or otherwise. To that end, the inquiry has done a number of things to assist it in ensuring that the most important issues are examined. These include publishing a list of those issues that the inquiry intended to investigate. More recently, the inquiry invited core participants to submit a list of up to 20 specific issues that they considered must be investigated. That was in addition to any such comments made in their closing statements at the conclusions of the various sets of hearings that I have already described. Core participants were asked to list those issues in order of priority, so that, if the inquiry is not in a position to address each and every issue, those issues that I consider are most important and those that the core participants consider are most important will be addressed. The inquiry team are presently reviewing the list of key priorities submitted by core participants, and I extend my thanks for their careful consideration of the issues. I also want to take this opportunity to explain our relationship with the UK COVID inquiry. While both inquiries are exploring what happened during the pandemic, the Scottish COVID-19 inquiry has different terms of reference and will report only to the Scottish ministers. This inquiry's terms of reference require me to make reasonable efforts to minimise duplication of investigation, evidence gathering and reporting with any other inquiry established under the Inquiries Act. That means the UK COVID inquiry. As I have explained previously, both inquiries cooperate to avoid duplication where possible. Today, I want to say something about reporting. The UK COVID inquiry has already published reports for its first two modules, both of which include recommendations. That inquiry has indicated that a further 8 module reports are to follow. To fully comply with this inquiry's terms of reference, we will require to consider those reports and the recommendations they contain. There may be a more detailed review of some matters in regards to what happened in Scotland, and I may make additional recommendations. However, it is also the case that if this inquiry agrees with the findings and/or recommendations of the UK COVID inquiry on a matter covered by this inquiry's terms of reference, this inquiry will not duplicate the reporting, since to do so would amount to unnecessary duplication. In those circumstances, reference will be made to the appropriate parts of the relevant UK COVID inquiry module report. Nothing of what I have just said should be taken to mean that this inquiry will not conduct its own investigation of matters investigated by the UK COVID inquiry. I simply wish to make it clear that, where the same conclusions are reached, comments in this inquiry's final report on those matters will be more limited than might otherwise be the case. In a similar vein, where a witness who has given evidence to the UK COVID inquiry is asked to provide a statement to this inquiry, the information contained in their statement to the UK inquiry will be admitted into the evidence of this inquiry without requiring to be restated. Insofar as possible, this inquiry will limit itself to asking those necessary additional questions to allow us to complete our investigations. Turning to the third set of issues, I would like to address some procedural matters ahead of our next set of hearings, which will run from the 5th to the 23rd of October. On the 23rd of February 2026, I made a direction that all core participants will have leave to appear for the implementation hearings. The full detail of that direction can be viewed on the inquiry website. All core participants can, A, expect to be given copies of documents to be referred to at the hearings prior to these being made available to the public and in advance of the hearings taking place. B, request counsel to the inquiry to ask certain questions of witnesses subject to the Rule 9 procedure, which I will touch on later. And C, subject to my direction, make closing statements. On 2nd March 2026, I made a direction that A, core participants will not be invited to make opening statements either in written or oral form. B, counsel to the inquiry will not make an opening statement at the commencement of the hearings. This direction is available to view on the inquiry website. Turning to Rule 9 questions. Thank you again to our core participants who provided feedback to the inquiry in respect of the Rule 9 process for asking questions in advance of or at the hearings we held in September last year. We have taken on board this feedback and have revised our process, which will be circulated to core participants for their consideration and comment at the end of this week. I intend to invite closing statements from core participants in respect of the implementation hearings. 2 days will be set aside for this on 17th and 18th November 2026. Closing submissions will be subject to a word limit and a time restriction. I will provide a direction in respect of closing statements later in the year. For both implementation and decision-making hearings, I intend to issue the oath, or administer, I should say, the oath or affirmation. I intend to cite witnesses for the upcoming hearings under Section 21 of the Inquiries Act 2005. As I have already stated, these implementation hearings will be short in duration, lasting no more than 3 weeks in total. These hearings will highlight the key issues identified for each implementer. Core participants should expect a focused list of witnesses. It is unlikely that more than 2 witnesses per implementer will be called, and it may not be necessary to call a witness for each implementer. Excuse me. The implementation hearings will focus on the key public bodies and organisations responsible for giving effect to the decisions of the Scottish Government during the pandemic. The hearings will consider these issues in respect of paragraphs 2A to L of the inquiry's terms of reference. Evidence has been ingathered across the implementation work streams through A, Section 21 notices for written statements and documentation, B, witness statements, C, review of evidence from the inquiry's impact hearings, D, review of evidence ingathered by Let's Be Heard, and E, review of witness statements given to the UK COVID inquiry. In no particular order, the organisation the inquiry refers to as implementers are local government, COSLA, NHS Territorial Health Boards, NHS National Services Scotland, Healthcare Improvement Scotland, Public Health Scotland, the Care Inspectorate, the SQA, the private care sector, the Scottish Courts and Tribunal Service, and Police Scotland. These bodies and organisations have been identified for a variety of reasons, such as that they may have had A, statutory duties in respect of the delivery of services such as social care, education and health, B, regulatory responsibilities, or C, being category 1 responders. These bodies may also have been responsible for D, the health and well-being of the population, E, the provision of information to the public in respect of health services, F, providing expert advice to the Scottish Government, and G, the provision of care. This is not an exhaustive list, but gives an indication of the reasoning behind these organisations being identified as relevant to this stage of the inquiry's investigations. In addition to the investigations into the key implementers above, the inquiry is also carrying out investigations into the implementation of pre-pandemic planning and the resilience framework for dealing with emergencies such as the pandemic. Further details of these procedural points will be published on our website shortly. I also intend to hold another short preliminary hearing in August to update co-participants on any outstanding procedural points. This completes all the remarks I wanted to make at this time. We will now break for 40 minutes. I will accept questions emailed to the co-participants' mailbox 20 minutes from now. That is, according to my watch, at 10 minutes to 11. So at about 10 to 11, I should receive these, and we will reconvene in approximately 40 minutes at 10 past 11. Thank you all very much. Now, good morning again. I'm aware that I indicated that I would come and give you the answers to the questions in 40 minutes. In fact, it's about 42 minutes since I gave that undertaking. I apologise. We're still working on the answers. There were a number of questions, and we'll be able to answer all of them today. But to enable us to do that, I'm going to adjourn now for a further 20 minutes. I apologise for the inconvenience, and I hope you appreciate the reasons for it. Thank you very much. Now, good morning again, and may I apologise, I think I slightly overran my time. I apologise for that. We had a number of questions to consider. Now, we've received questions from Scottish Care, the STUC, Scottish Hazards, SWRO, Long COVID Kids Scotland, and the Scottish Healthcare Workers Coalition, which all ask when disclosure will be made. The answer to that is disclosure will be given 8 weeks prior to the commencement of the hearings. That's 8 weeks prior to the 5th of October 2026. They also asked if we will disclose UKI, that's UKI COVID inquiry evidence, and if some disclosure will be made early. And the answer to that question is that UKI evidence will be disclosed in respect of the witnesses we intend to call. We will disclose early if possible. We, independently of those questions, received a number of questions from Scottish COVID bereaved. These questions are as follows. 1, this inquiry started earlier than the UK inquiry, yet the UK inquiry has reached the report stage dealing with important issues. So why, after an expenditure of £50 million by the Scottish inquiry on a far smaller scale, it has not reached hearings, never mind the reporting stage? And my answer to that is that the question is neither within scope, nor is it in certain respects factually correct. Secondly, the question from Scottish COVID bereaved asked, we were asked what our important issues were 3 years after the inquiry started, but in the interest of transparency, can we see the lists of other co-participants? And the answer to that question is the various lists provided will not be issued. The inquiry has published its list of issues and will in due course publish its revised list of issues after taking account of all key matters identified by co-participants. The third question for Scottish COVID bereaved was, why are the decision-making hearings taking place in 2027 and when? Why is it back to front and after the implementation hearings? And my answer to that is that both aspects of this question have been answered in the speech I gave earlier this morning. The fourth question from Scottish COVID bereaved was, we have been told by numerous epidemiologists that the next pandemic could happen at any time. Why then are we waiting until 2027 to hear from the decision makers? And the answer to that question is that this has already been answered in my speech earlier this morning. And the fifth and last question from Scottish COVID bereaved were, why are we not allowed opening statements? And the answer to that question is that it is a matter for my discretion. Co-participants are here to assist the inquiry, and accordingly I have put in a procedure which I consider is the optimal way of proceeding and conducting the inquiry. So those are the questions and the answers, and again I thank you all for listening this morning and for participating as you have done. And I now close this preliminary hearing, and as I've already said, there will be a further proceeding in August of this year. Thank you very much indeed.